state of Tennessee and this honorable court. Be seated.
Good morning. Just a reminder to everybody that the case will be live streamed as arguments going on, so just keep that in mind. I don't know that we have any that involve any minors, but if we do, try to avoid using their names or whatnot. Court's open to the public, but we don't necessarily need to put children's names and everything about them out on the web to the extent we can avoid it. Call the first case, please.
Timothy Charles Cooke versus Rita Moses Cooke.
Good morning. We'll hear from the appellant.
Yes, my name is Chrissy Lindsay from the Hamilton County Bar.
Counsel, could you stand in front of the microphone so we can hear? Thank you.
Yes, this is the first time I've been before you in person, so
Glad to have you here.
thank you, Judge. Madam Clerk, may I reserve 5 minutes for rebuttal, please?
That'll be fine.
Thank you. May it please the court, this case is a divorce action. There are no minor children involved. The key points that I'd like to point out regarding this brief are in regards to the classification of the largest asset I claim is from the marriage. What makes this case interesting is that there are two memorandum opinions. There is one from July 7th and one from September 30th of 2021. Those opinions I find difficult to read consistent with each other. And the reason for that is because in the first opinion, the July 7th memorandum opinion, it deals with the classification of a Pacific Life annuity. This Pacific Life annuity was $1.4 million and some change at the time of the final hearing. However, the court found that the appreciation that was contained in the Pacific Life annuity from the husband's premarital 401ks was marital property and properly classified as marital property based on the substantial contributions of both parties. However, in the numerical tables later in the memorandum opinion, the numerical value placed on that appreciation was only $84,000, which was actually the amount of the monetary contributions during the marriage, and did not account for the non-monetary contributions that were held in the appreciation, resulting in a discrepancy of $596,984. This is not a small discrepancy. This resulted in motions to alter or amend being filed by both parties. I suggested that the numerical value needed to be corrected because the written findings contained in the July 7th memorandum opinion were very clear. The written findings said twice the appreciation is marital. The actual words were, the husband's 401k appreciated during the marriage as a result of the active management of the parties during the marriage. The appreciation is marital. It was actively managed by both parties. It was converted to the Pacific Life annuity after wife met with a financial advisor at the request of husband. The invested amount of $741,947 is separate property, but the appreciation is marital. Your Honors, the appreciation can be marital, based on 36-4-121 B1BI. And that has long been a provision in the law where the parties, through their substantial contributions during the marriage, can make the appreciation in any separate asset marital and can change that classification. It's important to note that this specific life annuity was created during the marriage. Thus, the presumption is that it is a marital asset, and husband then bears the burden of proving any portion of that to be separate. Husband relied on a newer subsection that was created in 2015, which is the subsection B3. Okay, well, it's really B1, B3, all contained within that same section of the statute. And that provided that the appreciation on premarital retirement accounts, vested and unvested pension benefits, are separate because the doctrines of transmutation and commingling do not apply. Your Honors, with all due respect, we are not asking for the doctrines of transmutation nor commingling to apply. This is based on wife and husband's active management of this asset during the course of the marriage.
What does the record show this active management was? I mean, I understand just go ahead and tell me, what does the record show as the active management?
The record shows that the parties actively managed the accounts together. The record shows husband's admission that the parties actively managed the accounts, including the 401k, together.
What did they do?
They did a lot of things, Your Honor. The record shows that they were very active in making riskier investments. They met yearly regarding their operational budget. Wife was required to turn in receipts to husband. They had a living budget, which fluctuated.
Okay, but I'm asking specifically as to this account, this money that you're talking about. What did they do to actively manage the prior to the annuity and then after the annuity?
Using the investment strategies. So they were able to put it in riskier investments as a part of their overall financial plan. The record also shows that husband and wife did this together. So wife met with a financial advisor prior to moving the 401ks into this annuity, which that creates the nexus required for this account. It shows a pattern, Your Honor. An annuity is a very different investment than a 401k. And that annuity is designed for the benefit of getting monthly income for retirement purposes. While the monies were held in the 401k, they had a very strict operational budget, and they changed the strategies. Husband admits freely he was very active in management, the investment portfolios that he had, in managing all of the assets of the family. Husband also admits that wife was active in that management as well.
Excuse me for interrupting. Did the husband meet with a financial advisor before the conversion into the annuity?
Yes, Your Honor. Husband and wife both met.
They met jointly with the...
At separate times, actually, is what the record shows. To be clear, Your Honor, the husband contended that the wife did not do that. Wife contended that she did. There are credibility findings in the July 7th memorandum opinion that indicated wife's credibility was higher than husband's. And so the court then found that wife did meet with the financial advisor. The court made that finding in both the July 7th memorandum and the September 30th memorandum. What makes these two opinions difficult to read together is in the September 30th memorandum opinion, the court then tries to clarify its findings regarding the active management of the party, to Your Honor's point. And she clarifies that the wife met with a financial advisor at that point. What she then goes on to do is say the court declines to alter or amend its findings concerning the portion of the Pacific Life annuity that is separate property and what is marital property. That's in Volume 4, pages 494 to 495. By declining to alter or amend the other written findings, she's declined to amend her finding that the appreciation is marital. It makes these two opinions difficult to read in a consistent manner. The other thing I'd like to point out is nothing changed in between the July 7th memorandum opinion and the September 30th memorandum opinion. No new evidence was presented. There were no intervening changes in the case law. On July 7th, the trial court finds the facts support substantial contribution and classify it as marital in no unclear terms. On September 30th, the trial court finds that the appreciation is market-driven, but declines to alter or amend the findings regarding the portion that is separate and marital. Each time, the numerical value was listed as just the monetary contributions during the marriage, but the findings, the written findings, included the appreciation, which consisted of the non-monetary contributions and the monetary contributions that were made during the marriage. In Smith, this court addressed a Rule 59 motion that was used to correct a value. Rule 59 does provide a mechanism for the trial court to correct errors before the judgment becomes final, and it is reviewed for an abuse of discretion. Did the trial court apply the wrong legal standard? Was it an illogical or unreasonable decision, or was it based upon a clearly erroneous assessment of the evidence? It's our contention that the classification of the appreciation should be marital, as the court found both times, based on the substantial contribution of the parties. I believe my time may be up.
Yes, it is. You have your time for rebuttal. Thank you. We'll hear from the appellee.
Catherine White. Our response to said is the court did the right thing by clarifying what was stated in the July 7 memorandum opinion. The findings were wrong, and she corrected them in the September memorandum opinion. Both times, she still stuck with the $84,000 figure as being what was marital with respect to my client's premarital retirement. We had an expert testify, Matt Stelsman. His testimony was unchallenged. He clearly tracked the statutory language of 36.4.121 B1B little 3I, where he provided a reasonable method of accounting to attribute post-marital growth to premarital assets, even though contributions were made during the marriage. And that's what he was able to do, to go through and pull out what was premarital, what was contributed during the marriage, and then determine the increase using market-driven principles. There was no active management by these parties. It's not in the record anywhere that they actively met and called in sales, that kind of thing. It was governed by an algorithm that provides for market capitalization with a weighted index related to the 500 S&P companies. So there was no calling the broker and this kind of thing. It just sat in the account, and the algorithm made the choices about what to do, okay? The only thing that Mrs. Cooke did was she met at Ruth Chris Steakhouse one time when it was a marketing meeting to get people to come in and go with these folks for investments. You know, hire us, we'll help you make decisions to do about your money. She admitted that there was one meeting at Ruth Chris Steakhouse. There was no meeting with a financial advisor. The court was wrong when she said that. Additionally, the only thing that Ms. Cooke did other than going to the Ruth Chris Steakhouse was to agree for the funds in my client's premarital 401k to be rolled into the Pacific Life annuity. She did agree to that. She didn't sign any paperwork. It was still in my client's name. She wasn't the beneficiary if he were to pass. And so...
Counsel, did the trial court find at any time that the parties actively managed this account?
No. She said that they actively manage the household budget. Okay, that's a total separate matter than this retirement
But no
fund.
finding ever that they actively manage
No.
this account, including
She relied,
pre-annuity and after annuity.
she totally relied on the expert Matt Stelsman's testimony, and that's where the $84,000 figure came from. Even though she was misstating or stating findings that weren't correct twice, frankly, she still, though, hung on to the $84,000 figure that Matt Stelsman said was the marital portion of these premarital funds.
But I'm looking at, I think I'm looking at her first order, and I think what what she said was, the husband's 401k appreciated during the marriage as a result of the active management of the parties during the marriage. The appreciation is marital. It was actively managed by both parties. It was converted to the Pacific Life annuity after wife met with a financial advisor at the request of husband. The invested amount of $741,000 and change is separate property, but the appreciation is marital.
That
But
was
what you said, she said that first, but she went back and changed it?
Right. Initially, she was wrong about her findings. And then we filed our motion to point out there was an active management of the household budget, but that was totally different and separate from.
All right, but back to my question, the trial court did find at one point that they actively managed this account.
And then corrected herself.
The
Yes,
trial
sir.
court did find that they actively managed this account, correct?
Yes.
And then later changed it. Did the trial court, when it changed it, give any was there additional proof presented?
No.
Did the trial court give a reason why it changed it?
I can only assume it was because of
No,
emotion.
but-
But no, she did not.
Okay.
She just clarified that it was two things, that when she said active management, it consisted of that one meeting and then the agreement to convert the premarital 401k into the annuity.
Did the trial court at any time after that, what Judge Davis read to you, say parties did not actively manage this account?
She did not address that.
She just changed it. She said it was a market-driven.
And so relying on the cases, and I'm just going to point out real quickly, in Ogle, which is a 2017 Court of Appeals case, the court said that the contribution has to be real and significant, and there needs to be an actual link between the contribution and the increase. And then in the Sherrill case, 1992 Court of Appeals, which had come earlier, the court noted in that case neither party had actively caused there to be an increase, and the wife couldn't prove direct or indirectly that she was responsible for the increase. Langschmidt, 2003 Supreme Court case, clearly provides that appreciation of premarital investment is separate when appreciation is entirely market-driven and being a homemaker doesn't rise to the level necessary to create that link. And then in the McFarland case, 2001 Tennessee Court of Appeals case, the court there noted that when separate property increases in value with no contribution by either, the increase is separate. No matter what the contribution was as a homemaker or contribution otherwise. So when you're dealing with an increase in a premarital retirement fund, being a homemaker, that's not to say it's not important, but this statute and the case law makes it real clear that that doesn't play into an increase unless you are literally calling the shots on which stocks to buy, which things to sell. You know, you're managing the fund as opposed to an algorithm, which is managing the fund, which in its truest sense is simply market-driven. So it's our position that the court was correct in her figure of $84,000. She was vacillating on findings of fact, but the truth is, in the record, there is nothing in there about actively managing this account. It was actively managing the family budget. Wife admitted that she went to that one meeting, and that was it. And she agreed to the rollover. So That's my response to that. Do I need to talk about my cross appeal at this point, or what do you want me to do?
It's all in this 15 minutes, so.
Okay.
Counsel, excuse me
yes, sir.
for interrupting, but before we transition perhaps to a different issue, with respect to the equitable division of marital property, as I understand, initially the trial court awarded a 60-40 split, and with respect to the Rule 59 motion to amend, amended that to 70-30. Did the trial court articulate the basis, the predicate, the reasons for that change in the equitable division of marital property?
We filed a motion after Mrs. Cooke filed a motion to say, well, since we're here, we believe that under the Batson case that the percentage should have been increased as awarded to my client because he brought 97.7% of the assets into the marriage. Short-term marriage, Batson says you should restore the parties to the same position as if they'd never married or as close as you can. So when we brought that to her attention, she adjusted the percentage and paid homage to Batson. And so that's my understanding of why she did it.
Thank you.
Moving into my cross appeal, which is related actually to that issue, we believe that it was not an abuse of discretion to increase my client's amount, but we also think he actually should have gotten even more because of the 97.7% percentage that I just told you about that he brought into the marriage. And he had $1.1 million when he married. Ms. Cooke brought $26,000 into the marriage. So in light of that, we've asked the court to either A, give him 97.7% of the proceeds from the sale of the house, which was $460,000 they sold, and it's in the court registry, or restore him to the monies that he used from his premarital house to put on the down payment of this house, the 401k money that he used to pay for the HELOC, all premarital, and then the inheritance he received of $110,000 to pay down on that mortgage. That comes to $351,709. In the Hunt v. Carden case, which is your case, it came up here in 2020. I argued it. I lost. I was arguing transmutation had occurred when Mr. Hunt had taken his $146,000 from premarital monies and put it into a house that became transmuted. The court found that because it was a short-term marriage and in light of Batson, that this $146,586 should be restored to the husband. And that's all we're asking, that the monies that my client put into this house be restored to him as short-term marriage, or alternatively, he'd be receiving a larger percentage of those proceeds that are being held in the court registry because of what I just said. The other issue, we feel like the court was erroneous in her ruling that the bank account in question that had $84,000 in it was all marital.
Let me ask you,
yes, sir,
before you run out, they were married, what, 8 years?
They were married 6.5 years at the point that the divorce was filed.
And then they reconciled? Or was that after?
For a couple months.
So the answer is yes, they reconciled for a while. And then the divorce was picked back up.
Right. The total divorce from filing to the end was 14 months.
And so they were married 8 years. I mean...
Well, in totality, yes. I mean, if you
kind of look at for totality when you're looking at it from day to day. But what cases do you have? You've talked about short-term marriage, and what you stated is correct. But what are these cases looking at in terms of time?
They range from 6 years to 8 years. And I tracked the Batson case with the facts of our case, and it was very, very, very similar in my brief. Let me get this if I could, just a minute, and I'll go over it quickly. In Batson, the net worth was considerably larger of the husband than the wife's. Same here. In Batson, the parties were married for 5 years. Before the divorce was filed, they used that as the marker. And in this case, they'd been married 6.5 years before the divorce was filed. The income supported the parties of my client during the marriage, similar to Batson, with the wife making small financial contributions. Most of it was just domestic housekeeping, homemaker things. A large part of the marital property consisted of increasing the equity of the residence and contributions traceable to market-driven increases in the retirement, premarital retirement. Same thing as we have in Batson. So that's why we're saying that this is eerily similar. Batson, as I said, was that time frame, and then there was another one, and I apologize without pulling it. It should be in here.
All right. Don't use your time looking for that.
All right. So on this bank account, it was treated differently from day one in terms of the inheritance monies that my client received. He and his wife agreed to facilitate the distribution of these inheritance funds to the heirs, that they would each sign a check for, I think it was $15,000 or $25,000 apiece, to avoid taxable issues for the beneficiaries of these monies. 10 days after that money was in the bank account, it was moved to my client's separate account. Proof showed that Mrs. Cooke was not really wanting to be married to my client anymore, so it was moved. With that short 10-day period of time, the court deemed that all that money that my client received that would be traceable to his portion of the inheritance was transmuted, and we just disagree with that. They both agreed to treat the inheritance money differently, and that's what they did. And then it was in the joint account for, like I said, 10 days. My client moved it, so out of the total $84,000, we were able to trace $70,000 of it attributable to his inheritance. So that actually leaves $14,000 to divide and not $84,000 to divide.
Counsel, your time's up. But can you give me?
Yeah.
Can you give us just a bottom line of what, in dollars, of what you say, or percentages, what you say that your client should get of whatever is determined to be the marital estate, and what the ex-wife should get?
Well, we believe he should get, if you give him 97.7% of the funds in the court registry, that would be $450,000.
I'm asking if you can say, for whatever the total you say that is the marital estate, that it's your position, this is the marital estate, what percentage of that do you say your client should get? And
okay. 97.7%.
97.7% of the marital estate. Okay.
Or, can I give you an option?
Certainly.
Okay. Or $351,709 out of the house. He should get $70,000 of that bank account that I just told you about, and only $84,000 is subject to division for purposes of the Pacific Life annuity that we talked a lot about this morning.
Okay.
Thank you.
Thank you. We'll hear from the appellant rebuttal.
I would point that the trial court noticed the same thing. While not actively stated as such at the trial court level, the trial court noted in the September 30th...
Pull the microphone up a little bit, please. Thank you.
Tyler. The trial court noted in the September 30th memorandum opinion that while he did not state it as clearly and succinctly as was just stated before Your Honor, he really wants the wife to be awarded nothing. Batson is distinguishable quite easily, not only for a longer length of marriage in this instant case, but also in Batson, there was a lot of talk about how the assets that were awarded to husband were not liquid. He had to exert some effort in order to make them keep the same value or retain their value. Also in Batson, it found that each spouse's contributions to the accumulation of the assets is an important factor, but also that a spouse's non-monetary contributions as a homemaker are relevant not only to the division of the marital property, but also to an award of support and maintenance. Okay? In Batson, her non-monetary contributions were not fully reflected by the division of the marital property due to the nature of the assets. I'm pulling this directly from the case. Some effort had to be made to collect accounts receivable and notes payable. She was awarded alimony and solido instead from the separate property of Dr. Batson. As you'll see in my table 7 attached to my brief, none of these assets require any collection efforts. None. These parties maintained a high standard of living. Ms. Cooke's alimony award totaled the sum of $2,400. It is very clear that Ms. Cooke's non-monetary contributions were not considered in the trial court's award of alimony. That is another issue that I am asking this court to address.
Did the trial court elucidate the basis for alimony, transitional alimony for 2 months?
There was not a basis for the 2 months. There was not a basis for the duration. The trial court did elaborate that the basis was due to Mr. Cooke's payment of the marital expenses. They resided together. Beginning of this case, Mr. Cooke got an ex parte order that kicked out the wife and his stepdaughter. There was no basis under the law for that, so it was set aside, and the parties resided together during the pendency of this action. However, Mr. Cooke had taken all of the marital funds and secured them, so wife could not access any of that. The trial court's basis for the alimony is basically that wife had a place to live during the pendency of this divorce. That also folds into the argument I'm making regarding my attorney's fees. The trial court declined to award attorney's fees. However, it is very clear through the evidence that Mr. Cooke paid his attorney's fees from marital funds as they came due, his attorney's fees and his expert fees. To decline to award my client her attorney's fees amounts to a double dipping. In effect, he paid his fees as they come due, reducing the value of the marital estate at the time of the final hearing. My client then effectively paid a portion of his legal fees, his expert fees, while she was forced to go into debt in order to just litigate her own divorce. I'm asking the court to set that aside as inequitable under the circumstances.
Did husband pay any pendenti lite spousal support?
No, Your Honor. There was a motion.
Excuse me, I apologize for interrupting. Was there a motion filed at the trial court to rule on whether to grant pendenti lite spousal support?
There was, Your Honor. I filed one almost immediately. Instead of having that set for a hearing, the trial court did not want to try this by motion, as I understood, and we just tried to get to a final hearing as quickly as we could.
So did the trial court ever rule on that motion?
Did not, Your Honor.
Thank
Briefly, thank you, Judge. One last thing before my time is up. I just wanted to point out in the record, the appellee said that there was nothing in the record that showed active management. On page 209 of the transcript, it's volume 6 of the record, the second volume of the transcript. Page 209, I asked the question on line 3. And during these yearly reviews, you went over your retirement planning as well as the accounting in the operational budget. Is that correct? Husband's answer, yes, we went over everything. No money was ever hidden from her. She always knew where it was until this crazy stuff started. Contextual clues is the crazy stuff that led up to the divorce and him moving the money. Question, and you made decisions regarding all of these accounts, including the 401k, together and actively managed these together. Is that correct? Yes, is his answer.
Counsel, your time's expired.
Thank you, Your Honors.
The court's thanks to both sides. We appreciate your arguments and your briefs on this.